Okay, I think we've got everyone from the waiting room. So good morning. Welcome to our Q&A for January 17th. Just quick, our usual opening reminders. This is for legal, for general information, not legal advice. So if you have a specific question regarding your governing documents, applications of statute, if we can make it general, we will. Otherwise, we cannot offer legal advice in this forum. And you would be getting an email from Chelsea stating that. Please stay muted during this Zoom so people can hear and minimize the background noise. If you have a question, please put it in the chat. And then 2 quick things. The proposed bill for making all common interest communities subject to Ukiwa is still pending. There hasn't been much, if any, progress that we're aware of. And it's still very early in the legislative session, so we don't know what's going to happen. The legislative session started January 8th. If you want to receive weekly updates from the WSCAI LAC, that's the Legal Action Committee, you can go onto the WSCAI website and opt into that. We strongly recommend, if you want to keep track of what bills affect common interest communities in Washington State, you go ahead and do that. Otherwise, we have the same information as everyone else and don't know what's going to happen or what the legislature is going to pass this session more than anyone else. So jumping in, because we have a lot of questions this morning. First question. Beginning in 2024, a new federal law will require volunteer board members to provide substantial personal information to the federal government under the Corporate Transparency Act. No later than the end of 2024, the beneficial ownership must be filed. Beneficial ownership report must be filed, which will include information such as directors' names, birth dates, home addresses, and identifying numbers such as driver's license, state ID, or passport for all individuals with substantial control over the corporation. It seems community associations, despite being not-for-profit corporations, are still subject to these requirements. Affected businesses must submit information on any person who has an ownership stake in or control over the company. That would include corporate officers, but could realistically include all directors as well. Willful reporting violations carry significant civil and criminal penalties. Should community associations organized as nonprofit corporations in Washington State plan to comply with this statute, or is the National CAI actively working on an exemption for community associations? So this particular legislation was adopted in 2021 to prevent foreign entities from creating shell corporations to launder money. And the way the legislation was drafted ropes in, I think, more than Congress intended. So this has been a massive topic on the CAI message board. If you are a member of CAI and get those messages, you can go onto into your profile and do a search, which I did yesterday to help prepare for this question. And there's a lot of discussion on that. But based on the information and from reading the statute, it's likely that if an association is registered or classified by the IRS as a 501c corporation, you are exempt. So double check with your accountant and see if you're registered as a 501c. If you're registered as a 517, which I think is another option, it's likely you have to comply. It's unclear from the information whether there are major efforts to exempt common interest communities from this legislation. So you have until the last day to file your report is January 1st of 2025. So contact your accountant and contact your congressperson or senator to inform them of these unintended consequences. And hopefully something can be done. Otherwise, you're going to have to probably file this information. And there were three questions on this week. So there'll be more information coming. Ken, did you have anything to add to that?
Yeah, so most HOAs are 501c entities under the IRS rules. They're either a 501 C4 or a 501c7. Your tax accountant can certainly help you with that. Those are types of nonprofit corporations which are not charities. And so the money they receive is not tax deductible, but they are nonprofit corporations. Second question, regarding parking limitations, our condos have no limited common elements. Can a board require or regulate parking in an owner's driveway? So this is a very fact-specific question, and we don't have anywhere near the facts we would need to answer, but it will depend entirely on the language of the declaration. And then the general answer would be, if the driveways are common elements, then yes, there is probably the ability for the board to regulate the common elements. But it's also possible that the driveway is inside the unit boundary, because it really depends on how the unit boundary has been defined. And so even if it was inside of the unit, because the unit is a block of land instead of interior walls in a building, there might still be the ability for the board to regulate what is in the driveway under other provisions of the declaration of CC&Rs or condominium. So the board may have the authority to regulate the exterior appearance, and it might be that whatever's going on in the driveway would affect the exterior appearance. And it also may depend on what's being parked or stored there, because there's a general nuisance prohibition in almost every set of CC&Rs or declarations. And so it might be that what was being parked in the driveway could be considered a nuisance or a violation of something other than it being parking. So you would be regulating an activity, not parking. So it really depends on what it is you're trying to regulate and why, whether or not it's a reasonable thing for you to do. And the details are so specific to your individual documents and circumstances that I can't give you more of a general rule. Any thoughts on that, Jennifer?
No.
Okay. I'm also doing the next question, which is, if we hold monthly open board meetings, when should the minutes of the meeting be distributed or made available to the owners? So my general rule would be that you make them available when they have been approved, because that's when they become the official minutes of the meeting. There is no set rule for board meeting minutes, the way that there is a rule for HOAs that the minutes for the association meeting has to be put out within 60 days. We do have some clients who post draft meeting minutes and mark them as drafts. I might have offered that in theory, the draft minutes should be going out with the board packet to the board members, because the board members need them in advance of the meeting in order to review and then approve them at the next meeting. But then Ukiah specifically states that unapproved board meeting minutes need not be provided to owners. So some of this really depends on what it is you're trying to accomplish. I would say that certainly if minutes have been approved, that they have to be made available to owners because they're a record of the association, and they would be required to be available under that new statute that was been revised last year. Anything on that, Jennifer?
No. So I have the next question, and it's again regarding the Corporate Transparency Act. So the question is, we've been getting communications about the Corporate Transparency Act. Can you please explain how this would specifically pertain to an association on what they must report, and how do we know if one is exempt or not? The explanation that was provided to us is a little confusing. And this statute is really confusing. I did a look and tried to go through the exemptions, and it's a huge block of text and not very readable. So,
I would offer, Jennifer, that HOAs and condo associations are not the target of this legislation, especially when one of the key things they're looking for is information about people who own or control at least 25% of the ownership interest. So unless you are a community with 4 or fewer units, then no one owner is going to control 25% or more.
yeah, and what this legislation is intended to prevent is foreign investment in corporations or setting up shell corporations to launder money. It's just the way this was drafted, roped in a lot more than the government was intending, I believe. So what the legislation requires is that unless exempt, any entity created by filing with the state's Secretary of State is a reporting company. Once an entity is a reporting company, details and information on beneficial owners must be provided to the U.S. Treasury Department Financial Crimes Enforcement Network. So beneficial owners are anyone who exercises substantial control over a reporting company or owns or controls at least 25% of the ownership interests. Substantial control is exercised either directly or indirectly, including as a trustee of a trust or similar arrangement through board representation, ownership or control of a majority of the voting power rights of the reporting company, rights associated with any financing arrangement or interest in a company, control over one or more intermediary entities that separately or collectively exercise substantial control over a reporting company, arrangements or financial or business relationships, whether formal or informal, with other individuals or entities acting as nominees, or any other contract, arrangement, understanding, relationship, or otherwise. So as Ken said, if you have 4 or less owners in a community, that would be substantial control because they own at least 25% of the ownership interest. Board representation, probably. However, if you are a 501c corporation through the IRS, you are exempt.
We'll update people if we get new information. How's that sound?
Yeah. This legislation is really specific. So, and given we have a lot of questions, we're going to move on. If you have specific questions regarding your particular community or whether or not you are exempt, please contact your accountant and then take that information to your community association attorney.
So I've got 3 questions about audits, which all seem to be related. So we'll cover audits. One of them is, how do you find out if the association needs to complete an audit or not? You know, one of them is, what are the requirements for annual audits for our homeowner association? We haven't done any since 2020. Our membership votes required, etc. And then the third one was, how can association vote against when they don't want to pay for an audit? Okay. So the general rule is that you should just assume you have to have an audit. And there are some ways to get around that if you follow the statute that governs your particular community. So for a homeowner association act, which is 6438, if your community has annual assessments of more than $50,000, then you must have an audit, but it can be waived if you have 67% of the votes cast at a meeting at which a quorum is present, vote not to do the audit. So the default is you do an audit. If you want to avoid the audit, you have a meeting, you have to get a quorum, and 67% of the people at the meeting vote not to do the audit. Okay. If you don't get a quorum, you can't avoid the audit. If you don't get 67% of those voting at the meeting, you can't avoid the audit. Okay. If you are a condominium, whether you're old act or new act, and you have 50 units or more, you just have to do an audit. You cannot waive it. If you have less than 50 units, then the owners are allowed to vote not to do the audit, but it requires 60% of the owners to vote not to do the audit. And that's not 60% of the people who show up at the meeting, that's 60% of all the owners. So just getting a quorum and voting is not going to be good enough. If you are a Ukiah community, then you are required to do an audit if your budget is more than $50,000, or excuse me, annual assessments are $50,000. If it is under $50,000, you can waive the audit if a majority of the owners, not just those in attendance to the meeting, but all owners vote not to do the audit. So these votes have to be done every year. You cannot write into your rules or bylaws that you're not going to do the vote, do the audits. These are statutory requirements. And so the option to just not do it because you think it's too expensive doesn't exist under the law outside of these particular exceptions. Now, if you have a requirement for an audit, and again, most associations do, and your board is not doing the audit as to, what can you do? Well, you can certainly bring to the attention of the board that they are failing to comply with the statute or failing to meet their duty of care. And I suppose that an owner could certainly sue their association for failing to do audits if they thought that was a reasonable use of their time and money. Because it is a fairly black and white statute. It's not like you can have a reasonable decision not to comply with the statute. We would advise all of our clients they need to comply with statute. So the most governing documents allow more opportunities for owners to require an audit to be performed. So it's very common to see language that 25% of the owners can require the association to perform an audit. That would be in addition to the audits that are required by statute. But there cannot be a provision in the governing documents to allow you to avoid the audit different than what's in the statute governing your particular community. Okay. So the only other sort of wrinkles in this is if your community does not adopt a budget with enough money to perform services, it might be that that's one of the services the board chooses to cut because it does not have the money to pay for other essential services like electricity and water. But then if that's the case, you've got a lot of other problems going on in your community, which I think you need to solve. So Jennifer, did you have any thoughts on that?
No. So the next question, what can a homeowner do when the board fails to enforce the rules, or worse, adopt policies that are contrary to the declaration, knowing the association voted against amending the declaration just a few years prior? So in most declarations, the owners have the same authority as the as the association to enforce the governing documents. So if this is something that you are very concerned about and want to spend the money, you can sue the association. You can, that's a drastic step. What we would recommend first is talking to the board, either during an owner's forum at a board meeting or sending a question in through the management company, asking why they're taking this particular step. You can try and see if there are enough owners who agree with you to call a special meeting and ask for the board to explain the situation. You can try to get elected to the board. If there are enough owners who agree, you can try to remove the board and have an election, or try to change the makeup of the board. You can also just vote with your feet and move. So enforcement of the governing documents is typically a board function, not a function of the ownership. So you have to either change the board's minds or get elected to the board yourself. And honestly, if you have a major problem with how things are running in your association, you can always sell. It's an extreme option, but it is available to you. Ken, did you have anything to add to that?
Yeah, that boards do have some discretion in enforcement of rules, and that's very clearly written into Ukiah. I think the case law supports it for all other communities. And so it's certainly possible for an individual homeowner to have a difference of opinion with the board on whether or not a rule has been violated and whether or not the rule should be enforced. So the the issue is not a clear, easy one. And as much as some owners will read their governing documents and find black and white, bright line rules, they don't always exist in the eyes of their attorney or their board members. And so sometimes it's a matter of trying to figure out what it is you're trying to accomplish. And especially if you are trying to enforce a rule just because the rule is written down and not because of some impact it has on the community, you might want to reconsider whether or not the rule is worth enforcing. And if it's not worth enforcing, you can change the rules. That's another option for the community. Next question. Once board members are elected in an annual meeting, and of them, 2 want to be president, to determine who becomes president, can the new board vote by majority to pick one? So the default for all communities is that in the absence of a specific provision in the bylaws or declaration, all of the officers, and the president is an officer, are elected or appointed annually by the board of directors. That is from the nonprofit corporation statute. And so a part of me doesn't understand the question, because the membership do not elect presidents at the annual meeting for most communities. At the first meeting after the board is elected, there should be a determination by the board, which is just a vote by the board members on who will be the president, who will be the secretary, who will be the treasurer. And that person serves as long as the board wants to let them, because in all communities, the board can remove an officer like the president at any meeting with or without any cause. They still remain on the board of directors. They just lose the officer position. We also generally try and remind people that the president has very little additional power over the board of directors or the community. The only additional roles the president has are to preside over the meetings and to help set the agenda for the meetings. And then they sign documents on behalf of the board of directors. Their vote is equal to the vote of every other board member, and they don't get to make decisions alone. So part of the issue that comes to our mind is, why are you concerned about, you know, the power or the role of the president? Because you have the ability to remove them at any time, and what they're authorized to do is only what the board of directors gives them the authority to do. So any thoughts, Jennifer?
No.
Let's see, I guess the next one is mine too. Is a condominium required to have smoke detector in a small storage closet of 70 square feet assigned for use by a designated owner? So we're going to just start with, this is not a legal question. This is a question regarding building code and fire code. And while I do have some experience with that, I would still say the person to check with is your building department and or your fire department, because those are the requirements that would need to be met. There's going to be nothing in your governing documents that is going to address whether or not a particular enclosed space requires a smoke alarm or heat detector. So, any other thoughts, Jennifer?
Not on that one. So the next question. We are in RCW 6438 HOA organized under RCW 2406. 6438-035 sub 4 states that the Board of Directors meetings shall be open for observation by all owners. Do owners need to be allowed an opportunity to speak as well, or only to observe? So 6438 controls, because that's the more specific statute. So 6438-035 sub 4 is directly regarding Board of Directors meetings. And the statute requires that all meetings be open for observation of owners and their agents or representatives, except for executive session. So typically a good idea, and our recommendation is to have an owners forum either before the meeting or after the business is conducted, where owners can address the board on any topic. You can and the board can regulate the amount of time used by individual owners. Typically, we recommend 2 or 3 minutes. The owners forum is for owners to speak, not to have a question and answer or an involved discussion with the board. If there is a topic that needs to be addressed or needs research, that can be noted and added to the agenda for the next board meeting. Ukiah communities do have a different rule. So if you are a Ukiah community, you are required to have an owners forum. And that statute is 6490-445 sub 2 sub E. But unless you're a Ukiah community, you don't have to have an owners forum. It's typically recommended that you do to allow owners to address the board and have their concerns noted. Ken, did you have anything to add to that?
No, I do think that you get fewer conspiracy theorists if you are more transparent and give people an opportunity to comment, but you do not have to allow them to engage in debates or argue with the association. And if you just let someone talk uninterrupted, it's surprising how little time they will need to voice their concerns. Next question is, we are a 6438 HOA community, 55 plus HOPA manufactured home community, where each owner owns the lot on which their home is installed. We're contemplating amending the declaration to require owners to own their home for at least a year before they are able to rent it out. Would this type of clause have any potential impact on people being able to get FHA or VA loans or to get FHA reverse mortgages? So the short answer is yes, it would absolutely impact the ability to get FHA mortgages and reverse mortgages, because currently the FHA does not allow any of what they call a seasoning clause, Seasoning meaning that the owner has to occupy the home for a period of time before they are allowed to rent it. We actually have started having clients request amendments to their governing documents to remove provisions like this that have been in place for 10 or 20 years because they were adopted with earlier rental caps. And at that time, FHA didn't care about the seasoning clause, but now they do. So the other thing is that if you are governed by 6438, the Homeowner Association Act, creating a restriction on use is much more problematic than it is for a condominium. And you've got case law like the Wilkerson v. Chihuahua case, which held that the particular restriction on use that was adopted by that community required 100% or unanimous consent by every owner. And whether or not you need the consent of an individual owner to put a restriction on their lot depends on whether you are modifying an existing restriction, which is generally allowed to be amended, or whether you're trying to impose a new restriction. And then it depends on how the amendment provision is written, because if the amendment provision states that new restrictions may be added, then you might be okay. If it's silent about new restrictions, then you're probably not okay. And any kind of a restriction on use for a community in a 6438 or Homeowner Association Act community is going to require a significant examination by an attorney to determine whether or not the facts and the language of the document will be supported when you have this contrary Supreme Court ruling from the Wilkerson v. Chihuahua case. Any thoughts, Jennifer?
No, I think you've covered it. So the next question, if a healthy tree that belongs to an individual homeowner falls onto the HOA greenbelt during a windstorm, whose responsibility is it to remove the tree? Double check your governing documents. There may be some guidance there. Ken's general rule is that the owner of the land the tree falls on is responsible to clean it up. The HOA cleans the greenbelt, the owner cleans their lot. You could check your governing documents. There may be a provision that allows the association to shift responsibility for certain damage caused by an owner to that individual owner. Please be aware, though, that if the declaration does not specifically allow that, you can't do it. And if it's not in the declaration, it's not enforceable and not collectible. Ken, did you have anything to add to that?
Yeah, the question says that it was a healthy tree. And so if it's a healthy tree, that means there's no negligence theory that you could use to assign the tree owner. And usually this question comes because it's a healthy association tree that's fallen on someone's lot. But I think that my general rule still applies. Next question is high-risk components amendment. Have you drawn them up, and what advice do you give or problems you've seen with them? What should they include or exclude? So a high-risk component amendment is something which usually goes for condominiums because the association is trying to reduce risk to the larger community because of problems within individual units. Hot water tanks being the most common, but this also relates to, sinks and showers and washing machines and dishwashers. Basically, we draft them fairly frequently. We include them in all of the restated declarations that we do. Sometimes they're done in conjunction with an insurance amendment, which is also trying to manage the risk to the association. There is in Ukiah already language which allows for you to use rules to adopt high-risk components, and that's helpful if you're a Ukiah community. Sometimes the amendments will specify individual pieces of equipment, like a hot water tank. Usually they will just authorize the board to designate by rule what those components are, and then to establish criteria like how frequently the hot water heater has to be replaced, or what kind of supply lines have to be used for the fixtures. And usually these give the board the authority to inspect and then require replacement, so that the procedures are usually set by the board. Okay, and that's done by rule or policy. The major issues we've seen are when boards forget to designate components. So they may have a high-risk component procedure or policy, and then never identify the hot water tanks. And the other thing is that they don't bother to exercise their authority to go in and inspect them. So they might have a rule that allows them to replace hot water tanks that are more than 10 years old, and they never check to see if the hot water tanks are more than 10 years old. So, in our mind, the problem generally comes more from the board sitting around neglecting their ability to inspect and find problems before they become significant. And my recommendation would be that you set up something where you are no less frequently than annually looking at the drain lines under sinks, the hot water tank, the washing machine, the dishwasher, ice makers. And I actually like to include that with an inspection of the interior of the units related to the association's responsibilities, like decks and windows and doors, to make sure that those are functioning properly. I'm actually a big fan of preventive maintenance inspections, and the high-risk component aspect is just part of a more comprehensive preventive maintenance inspection program. Any thoughts, Jennifer?
We do have a follow-up question in the chat. Is there a place to start to research for a good list of high-risk components, years till replacement, etc.?
I'm amazed at how much is on the internet that other communities post. I don't know that they're doing it for the rest of the world, but they don't bother to protect any of the information. So I would start with that. The Institute for Real Estate Management, I think, actually also has some books that are written for apartment house managers that probably has some nice lists of components there. If you've got a management company you're working with, they may be able to borrow for you from some of their other clients lists of components. And so I think there's a number of free resources that just require a little bit of inquiry.
Also, you can check with your community association attorney. This is high-risk components is something that is generally known throughout the industry. So your attorney may have a list that they've drafted for another client that they can provide to you. One thing I wanted to, oh, sorry.
Sorry, I'm not going to give away another client's work product without their permission. So the fact that I may have written 5 or 6 of these doesn't mean that I have the authority to give that information to you, because it belongs to my client, not to me. So sorry to interrupt.
No worries. And I just wanted to reiterate that unless you have amended your declaration to add this language, the high-risk components, or you are a Ukiah community, you do not have the authority to inspect. Check with your community association attorney if you have any questions.
You can ask, though, and
Yes.
we do have this in a number of communities where, you don't have the legal authority to require them to allow you to come in and inspect the hot water heater, but you could still ask, and you might be able to get into 80% of the units to do it just by asking. I think you're the next question, Jennifer.
Yes. So next question is, a property management company sends one courtesy notice to homeowners for a declaration or CCNR violation, and then charges the association for every follow-up notice they send relating to the same violation. This fee is separate from the specific fine charged for the violation. The fee is typically billed back to the owner. If a homeowner refuses to pay the fee because it is not specified in the CCNR's declaration that they have to repay the notice fees, is there any general rule that obligates them to do so? What wording needs to be found in the governing documents in order to cause homeowners to repay the association fees incurred by them beyond those incurred by late assessments, such as notice fees for violating the declaration? Could this specification be something that is added to the rules and regulations only? So Ken and I had a long conversation regarding this earlier this morning. There is an increasing tendency in the industry among the management companies to charge fees on top of like delinquency notices. So you get the late fee for the delinquency and then an extra fee for the company having to send a letter, or a fine for violating the governing documents, and then an extra fee for the management company having to send the letter. So unless there's specific language in the declaration allowing the association to shift costs of enforcement, or language in the declaration requiring owners to pay for services to their specific unit, there's no ability for the association to collect these costs. So one thing both Ken and Valerie have spoken about numerous times is that having both a fine and then a fee on top of the fine doesn't necessarily seem reasonable. If you're going to add a fee for sending a letter, you may want to increase your fine or late fee to include that cost. You would typically also need to give notice and opportunity to be heard before assessing these fees if they're allowed under the declaration. It's duplicative, and a single fee is a single fee for late fee or fine is better. There may be a way to assess these costs if the language in the declaration for misconduct is there, or your Ukiwa or 6434 community. For those particular instances, check with your community association attorney. It would be a very case-by-case basis, and it's unclear whether you could blanketly state that any violation is misconduct. If the owner refuses to pay a fee because of lack of documentation, you may need to have a declaratory judgment. You may need to file a lawsuit and get a court to determine whether or not those assessments are valid before it can be collected. So that would be another question for your community association attorney. Ken, did you have anything to add to that?
Yeah, I don't like, and Valerie has agreed with me, we don't like having both a fine and a separate fee from the management company for the same event. And this is not really a comment about whether or not managers should be charging separately for these individual services as they are provided. It's really a question of whether or not those individual fees would be passed on to the individual owner instead of being recovered by the association through their fines and late fees. And as more manager companies go to these a la carte, or you pay for every service individually instead of a blanket flat fee, we are seeing more of this kind of delinquency letter notice fee or violation fee. And we don't have an objection to managers being paid for services they're providing. Our problems come when you start assessing those to individual owners. Many documents allow you to assess a fee for a service provided to an owner. The problem is, I don't know that an owner could be judged to have a service provided when you're sending them a delinquency notice or a violation notice. And during the pandemic, when it was illegal to assess late fees, we were seeing clients who were assessing these admin fees instead. And our position was that they were not going to be enforceable unless we got a court to agree they were, because the intention of the governor's policies was to eliminate all kinds of late fees and interest during the pandemic. So what you're doing in assessing these additional fees is certainly a shift which the governing documents and the statutes did not anticipate. And so there's uncertainty about how they're going to be accepted by the courts. And the more simple you can make the ledger to the owner in terms of assessment of violation fees or fines and delinquencies, the easier it's going to be for them to understand, and the easier it'll be for a collections attorney to enforce in court. Those are my other thoughts. Next question. Currently, the information on delinquent account total dollars overdue is not included in our treasurer's report. I'm interested in any identifying information. I'm not interested in identifying information like unit numbers. Is there a statute that requires or prevents the delinquency information from being included? Seems like a measure of how well the association is being managed. I don't think the board has access to this information either. I don't think we have an adequate policy for delinquency and questions. I am able to obtain the information by making a records request, but this seems concerning. It appears that we have over $100,000 in delinquencies that are more than 120 days overdue. Do associations routinely include the delinquency account dollars? So our general answer is a delinquency report is typically part of the financial packet the board has from the treasurer or from their management company on a monthly basis. There is no statute in Washington that would prohibit publication of a delinquency report, though there certainly might be an interpretation of the new record statute which says you must redact the names of individual unit owners, but that wouldn't keep the total from being provided. I think that generally accepted accounting procedures would require that the delinquent dues be listed separately on the balance sheet from other assets like cash in the bank. Under accrual accounting, the assessments are income the day they are assessed, even if they're not paid. And that's sort of a little bit of a fiction in how the accounting world works. But if the money is not collected, it should appear on the balance sheet as delinquent or late payments, because it's not the same as cash in the bank. And so, I guess my general answer is that the delinquent account totals should be on the treasurer's report. Any thoughts, Jennifer?
Not anything more to add. So the next question. Does a mail-in ballot from a homeowner for a board officer where the homeowner cannot attend the meeting count towards meeting the minimum required attendees for quorum? So example, an annual meeting quorum is 40% of owners. There are 50 homeowners. 10 vote via USPS for board openings, and none of the 10 attend the meeting and do not submit a proxy. There are 18 different homeowners that do attend the meeting in person, attend the meeting in person, Zoom, or by proxy. Can the 10 votes be counted toward the quorum, giving a total of over the 40% minimum required? So this particular question is too specific to answer. We'd need to see the meeting notice and wording of the ballots submitted before we can definitively answer. So you would need to submit this to your community association attorney. In general, statutes for voting changed in 2021. So the new statutes to take a look at are 6432 280, 6434 340, 6438 120, and 6490 455. So by statute, absentee ballots count towards quorum if the ballot was prepared by the association. And Ukiah is clear, and this is 6490 450 sub 1. The absentee ballots count towards quorum, and we believe that the legislative intent behind this particular statute is that absentee ballots prepared by the association count towards quorum. But that's only if the absentee ballot was prepared by the association. So if you have a particular question regarding whether or not these ballots, whether or not these absentee ballots comply with statute and can count, please submit them to your community association attorney. Ken, did you have anything to add to that?
Yeah, if you're wanting to get more participation and have people able to vote by mail, then you and most communities can do an election by mail instead of doing it at the annual meeting. You do need to make sure that you don't have conflicting provisions in your documents or a requirement that you accept nominations from the floor at the annual meeting, because you can't have a valid absentee ballot that goes out and then also accept nominations from the floor. So if you want to deal with elections by mail, which I think is a fine way to do things, you just need to make sure that you're doing it procedurally correct, and you're going to need some help from an attorney to do that. Next question. I have a question about meetings from Ukiah. I thought it was a requirement to send an agenda and other board packet items 14 days in advance. But it looks like there's only a requirement to send a notice, and that the time restrictions are voided if a schedule of the meetings is posted and issued ahead of time. So I think the short version of this question is, if you have to give notice in advance, when do you have to provide the agenda or the other information which is provided for in the statute? And so I think that if there's a standing meeting, that there's no requirement to actually send agendas or any of the information to the owners. The statute says that those documents must be made reasonably available to the owners, but what is reasonably available might be 3 days or 7 days. Certainly 14 days would qualify as reasonable, but that doesn't mean that it's going to be available, and it doesn't mean it's going to be sent to owners. It might just be posted on a website. I have at least one client that has a policy of making all of the documents for the board meeting available 72 hours ahead of the board meeting on the association's website, so that if owners want to look at it, they can do that. And there are still some documents that would not need to be made available if they are protected records under the most recently adopted record statute for every one of the community association statutes. Did you have anything else to add, Jennifer?
No. So our last question, and we can probably cover this in the remaining 6 minutes. If a board puts a discussion item on their agenda, but not a voting item on the agenda, can they still end up motioning for an action on a discussion item? So there's really no hard and fast answer here. There's no statute or regulation that requires discussion items remain discussion items or anything like that. So if for a board meeting, and this is a board meeting, not an association meeting, for a board meeting, items on the agenda can still have motions made and voted on by the board as new business. Some things may require advance notice, like removal of a board member must be on the notice sent to all the owners. Well, that's for an association meeting. So for a board meeting, things requiring advance notice would be things like a contract that must be reviewed. Invoices could be dealt with at the meeting or dealt with separately. That's up to the management company and the board. One thing to always remember is it reasonable? And then what the board can do may not always be what they should do. So if you have an item that comes up and you weren't able to get it on the agenda, but it must be voted on by the board, as long as the board members have adequate time to discuss and review, you can still go ahead and take a vote at that same meeting. If the topic is already on the agenda, the board is aware and able to discuss it, there's no reason why you can't take a vote, as long as it's reasonable. Association, oh, I'm sorry.
I was just say, I did think of an example where you could not vote absent a motion being presented to the membership in advance of the board meeting, and that would be under Ukiah. To adopt a rule requires that the rule be sent to the owners so that they can comment on it before the board votes. So there is a procedural requirement for rules built into Ukiah, also for corrections to the declaration, which the board can make alone. That also requires that it be sent out, and the exact wording of it needs to be sent out to all owners in advance of the board making that motion. So those are examples where they could not act without the full item on the agenda with a motion. Sorry to interrupt.
No worries. And then, as I said before, association meetings are different. If there is something that must be brought up for an association vote, typically that needs to be noticed so owners are aware and should not be brought up and voted on at the same meeting. Ken, did you have anything more to add to that?
No, I'm good on that.
And I believe that was our last question. Do we have any questions in the chat?
We do have a question. Association sent out annual meeting announcement, which only included one agenda item of voting on annual budget. However, at the meeting, 2 additional items were added that included voting on board members and voting to allow the board to enter into a lawsuit if needed. 54% of membership attended the meeting. Since the meeting announcement did not include the 2 vote agenda items, are they legitimate?
This is too specific and we can't give legal advice on this in this forum.
Check with your community association attorney.
So I think we just wrap it up with that then.
Okay.
All right. Well, thank you, everybody, and we'll see you next week.
Have a good week.